Criminal Justice System in England by Maria Benicoli. Introduction to Criminal Justice System in England. The criminal justice system is a lot like the justice system in the United States of America. We will look at how a court proceeding is conducted from arrest to sentencing. Crime rate in England. According to Datablog, the crime rate in England has fallen by 8% in recent years. The majority of crimes that are being committed are cybercrime and fraud. Not every crime is reported to police, making it hard to know the actual figure of crimes that have been committed in England. Young adults are more likely to be victims of fraud and elderly in England. They are high risk of being taken advantage of because people see them less able to defend themselves. Police officers in England. In England, to become a police officer, you don't need to have a college degree, but you do need to be able to handle the stress on the job and be able to perform at the optimal level for what it takes to fight crime. Most officers are also patrol officers in England. The police in England are made up of people that are Caucasian, more men than women, serve on the police force. They have to hire by law people of different races and ethnic backgrounds. The role of police in England is to make sure that the roads and the country is safe. The main role of officers in England is to make sure the citizens are safe and taken care of. Officers in England's main responsibility is to patrol and make sure that people are obeying the law. These officers are called patrol officers. And also in England, most of the officers also don't carry guns as well. In England, there are a number of crimes that don't get reported to the police each year. Overall, there are not many police reports made of antisocial behavior or police doing things that would go against the police code of conduct. And the police code of conduct is very similar to the United States code of conduct, where they have to do things that are ethical and morally correct, such as not breaking the law themselves and using too much force that's not necessary to bring in an offender. History of England system compared to the United States. With our judicial system coming from England by how we conduct a court proceeding, we begin to understand the history of how a court proceeding is like in England compared to the United States. Our judicial system was deprived from England's judicial system. While we have a lot of similarities, there are differences in the process. In England, you can only plead not guilty or guilty. The United States of America, we have more pleas such as no contest, no not guilty, for reason of sanity. I may repeat myself. Offenders in England and brought to trial. When an offender is brought in after they are arrested in England, the country of England follows a certain protocol before trial. In England, upon arresting an offender, the police must use a full code test to determine if they have enough means to charge a person with a crime. The full code test is a test where they see if there's enough evidence for them to bring charges against a person in the United States of America. We have what is called an arraignment hearing. That is the purpose of seeing if they can hold an offender. And England does have an arraignment proceeding similar to in terms of America's, where an officer there go before the court, and the court, after law advisor writes the indictment, I think it's called, then they actually then proceed to a full trial, or their charges are dismissed. The ways in which England court proceedings stat of England. The American judicial system comes from the England judicial system. We handle court proceeding the court proceeding in England. In a court proceeding in England, just like the United States, the accused has the right to a fair trial and have the right to trial. In England, just like the United States of America, you have the right to have counsel at every step of the court proceeding. The trial follows the same steps as it would in a court proceeding in the United States. In England, you have the prosecution and the defense. The prosecution takes the stand first, then the defense takes the stand. And also in England, the lawyers are referred to as case advisors or law advisors. That's different than America, where we just call our lawyers attorneys. Criminal justice process is made up of the justice process is made up of the prosecution office that handles what prosecutes the case, just like in America. The courts that are made up of the judge, oftentimes and what is actually they also have different like levels of courts, like the United States, where our highest court of the land, of course, is the Supreme Court, and they have a very similar type of triad of courts. I'm assuming the prisons and the probation office. The prisons is basically where offenders get sent for their sentences if they do get jail time. And the probation office is basically like the America's probation office, where they also, when an offender is released from jail, then they receive probation, or that the court will watch usually the offender for like a year or so after the actual offense has occurred. The outline of the criminal justice system. Just like in America, but also in the case of England, they had the Crown Court. It was kind of like their court that is their main court. That also oversees most of the cases that are being taken, and also, I believe, if I remember correctly, the Crown Court is also also one of the highest courts. I may be wrong about that. The Crown Prosecution Office is where law advisors create the indictment for the criminal charges to be given. An offender appears in the Crown Court for an arrangement and prosecution of an offender. When an offender is found guilty of a crime, then the judge is given a sentence in the process called court proceeding. For a prosecutor to bring charges against a person, they need to prove beyond a reasonable doubt. This is also true for America. For a case to be prosecuted, it has to be beyond a reasonable doubt, meaning that there's enough sufficient evidence to prosecute the offender, and it's the same in England. In prosecuting a case in England. England prosecution of offenders. The Crown Prosecution Office, Defense Counsel, adjudicates the person found innocent or guilty. The Crown Prosecution Office is much like the American Attorney General Office in each state the person resides in. When an offense goes to trial, the Crown Prosecution Office handles the evidence the prosecution will present at trial. Their objective is to make sure that the offender is found guilty in a court of law. Defense counsel is made up of the law advisors that are going to try to prove beyond a reasonable doubt that the person didn't commit the crime. The defense has several members on their team, such as the Secretary of State, the Senior Service Officer, Senior Official Minister, Parliament members under the Secretary of Defense, and the Chief of Defense. These members are there to make sure that the offender is given a fair and equal trial, just like in the United States of America. But also to be noted is both sides have to actually, the defense has to, of course, provide services for the offender, and the prosecution office is mainly there to make sure that the person is being charged, if they deserve to be, charges deserve to go forward against the offender. The defense of people that are poor. Defense counsel for people that are poor, and how is it funded? People in England that are deemed poor, commit a crime, and are able to get a lawyer from the Crown Court. The court offers them a lawyer that is paid by England, so they are given the right to counsel. In the United States of America, we follow the same thing, except for America, it's a state-by-state thing. We give each offender the right to counsel by providing them a public offender. Like England, we say that it's a right for a person to have honest and fair trial at court. United States of America, we can waive the right, but are warned about what we're doing. The main reason difference is that the person needs to show they have a serious crime and they cannot afford to present them at trial. And basically, England's government also, like, they're basically paying for you to be represented in court because they see it as a very fundamental right, just like America, that we have a right to fair and just trial. How a person's found guilty or not guilty in England. England's jury system versus America's jury system. In England, when an offender is found guilty or not guilty, it follows the same principle like in the United States of America. In England, you have the right to a jury trial where a group of your own peers must find you innocent or guilty. For a person to be found not guilty or innocent, they must believe beyond a reasonable doubt that a person is guilty of a crime. This allows a fair and equal trial of the offender. In the United States of America, you can request a bench trial and waive the right to a jury that made up of your peers. This helps to ensure that the judge is not biased and the case will be fair. The main reason why England does not have a bench trial that I know of, unlike America where we can request a bench trial to basically avoid a jury trial, because jury trials are usually longer than bench trials, and the judge has full control if it is a bench trial. The tier court system in England. The court system in England is made up of the Crown Court, the first tier court, second tier court, and third court. So basically, the Crown Court is the highest of the land, and the Crown Court is the lowest of the land, sorry about that, and third tier court is actually the highest of the land. We in America have we have the same kind of thing, except for our highest court of the land is the Supreme Court. Of course, that also handles the most serious crimes, and the Crown Court handles the lowest, or the Magistrate Court. I'm probably saying that incorrectly, but they handle like the very minor crimes in England. The trial process in England. Restriction on evidence and plea negotiations in England. There are restrictions on evidence that can be presented in trial. This helps protect the offender and safeguard any use of evidence that's not necessary. The process is called the burden of proof. Is what we like is like what we use in the United States of America. We use court hearings to where the defense can listen to the evidence being brought to trial. Also, with restrictions on evidence, the prosecution in England has to prove that the evidence being used on their side, there's actually a tie to the offender, much like the United States of America when evidence is brought into trial. England does allow plea negotiations, but there's like restrictions on their use, like it can only be used in certain crimes and it cannot be used for serious offenders because they believe it's an ethical dilemma if they use plea negotiations as a way of lowering a sentence. It has to be a just reason. The sentencing procedure in England. Being charged with a crime in England. When you are being charged with a crime in a weighing trial, you are given a charge sheet that lists all the crimes that you are being sentenced with and being charged. The lowest court, Magistrate Court, handles low-end crimes are allowed to impose short jail times and fines based on several factors. You can appeal your case, and this can go to a higher court, just like in the United States of America. The Crown Court often is the one that can bring sentences for crimes for an offender. All courts can give out punishments such as fees and jail time. Like I mentioned earlier, the Magistrate Court is actually a part of the Crown Court, and so it kind of handles the same thing.